Got that recording on. Turn the time over to Jim Wright from Property Rights Ombudsman's office.
Right. Well, thank you, Jason. I sure appreciate that. And first off, I am Jim Wright from the Office of the Property Rights Ombudsman, as Jason mentioned, and really appreciate the trust inviting us to come and do a presentation today on eminent domain. Appreciate Jason's and Lance's help here technically, and looking forward to spending the next few minutes with everyone and talking about eminent domain. And as Jason did mention, we are a state agency that is tasked with helping both property owners as well as condemning agencies and authorities with understanding eminent domain law as well as resolving disputes. And really one of our office's primary purposes is to help avoid and resolve disputes. And one of the ways that we do that is by educational presentations. And we're also certainly available, as I know some of you have already taken advantage of, to take calls from people, or whether it's property owners, as most people think of us for, but also we take a lot of calls from condemning agencies as well, and we're happy to do that. So we're here to just to help educate and basically try to avoid and resolve disputes, as I mentioned. So today, as you know, we're going to be talking about eminent domain. And per the write-up that was sent out about this presentation, we're going to be talking about three main things. The first one is I'll be talking about an overview of the eminent domain process. And the idea there is to give you a pretty good picture of some of the main legal requirements in case a public project necessitates acquiring some property from some of your citizens or constituents there. This isn't meant to be an exhaustive overview, it's an exhaustive view of the entire body of law, but it should give you a pretty good idea of what's out there and what to keep in mind when you're doing this. And as always, we're happy to take specific questions in our office, and we do meet on a reasonable basis actually with folks who are having a condemnation project, and they want to come in, and they don't do it very often, and so our office is available to go through that with people. After the overview of the eminent domain process, we'll be talking about property owner rights, because sometimes public projects do necessitate acquiring private property involuntarily. And so we want to highlight some of those rights to make sure they're respected. And again, this is in the purpose of trying to avoid disputes and help everyone with their PR and reducing litigation. And one of the best ways to do that is to simply respect people's rights. As well, we will be talking about some of the hot eminent domain issues right now. And there is a bill currently being set up to be run this next legislative session dealing with some eminent domain matters. And so we'll talk about that. Okay, so the eminent domain process. Let's start off here with the definition of eminent domain. Here's one for you. And by the way, eminent domain and the term condemnation, I'll be using them interchangeably. For our purposes, it's the same thing. And so, it's the legal process to acquire property that's needed for a public purpose after payment of just compensation. So we see here that there are a few things involved. It's going to be, property that is for a public purpose and need to pay just compensation. And this is oftentimes, or can be, an involuntary process. Sometimes folks are okay with selling the property. In that case, it's not, there's no eminent domain use there. But when folks aren't willing to sell property for a public purpose, sometimes the eminent domain is the name of the process that will involuntarily transfer title over to the agency for the public purpose. So there are some constitutional underpinnings here to the requirements to go ahead and move forward with an eminent domain proceeding. The first one is found in the Fifth Amendment to the United States Constitution, and that states that nor shall private property be taken for public use without just compensation. And then at the state of Utah, has a similar constitutional provision in Article 1 of Section 22 that states that private property shall not be taken or damaged for public use without just compensation. And so we'll be talking a little bit more about the just compensation part of that, but it's important, I think, to understand as an initial matter that that's a constitutional requirement, not just statutory. After that, most of the eminent domain law for Utah is statutory, as with any state. And so one of the things to understand here about Utah's statutory context is that it is a purpose-driven context for eminent domain. And what that means is we're not so concerned in Utah with who exercises the power of eminent domain, but rather the question is, for what purpose is it exercised? And so, you know, one of the issues that we addressed here leading up to this coming legislative session is, you know, should we take a look at Utah's laws and should we address who has the power of eminent domain? And one of the things that this group of stakeholders that our office was involved in facilitating these conversations, you know, people from the property owners, from governments, from other folks, utilities who might be involved in condemnation, most everybody said, you know what, we like the way it works now where we're focused on who, where we're not focused on the who, but rather on the purpose. And so, you know, that's the way Utah's set up, and it doesn't look like that's going to be changing. So when you have a project, a public project, where it looks like you need to acquire property involuntarily from folks, the first question, the first requirement of the statute is you need to make sure that the planned use is an allowed use under the statute. And I've got these statutory sites here for you, so you can use it as a reference to go back and look these things up. So there's a list there in the statute that I've cited of the acceptable public uses for eminent domain in Utah. And so again, the first thing to do is go check that list and see if it's on there. Because if it's not, then you know that's the end. There's no right to continue forward with eminent domain for that project. Another thing that needs to happen under state law is the taking of the private property needs to be necessary for the use. There's a statutory provision here that requires that the project be located and the property taken be done in such a manner that there is the greatest public good with the least private injury. And so that's something to keep in mind as you were planning your projects and deciding where to locate them and how to go about the acquisitions, is to you know, make sure that you're getting the biggest bang for your buck is the bottom line here. And for the private injury there, you know, the biggest bang for the private injury, and that they're located in such a manner that, you know, people aren't unnecessarily hurt. Sometimes you can tweak the project a little bit, and it makes a big difference for people without really harming the project and making it more expensive. Oftentimes, or pretty much always, if you're going to be doing a project, you need to go ahead and have it surveyed and have some inspections of the property done to make sure that what you're doing is going to work based on the physical nature of the land. And so, you know, you need to access people's private property. And under state law, this can be done, but there's two requirements. And that is that it has to be done at a reasonable time, and there has to be a reasonable notice prior to doing this. So, you know, even though this is a legal requirement, just as a practical matter, if property owners see people out there traipsing through their backyards and they didn't have any notice of this, it's going to send them through the roof. If that's how they find out that their property is being looked to potentially be acquired for a public purpose, it's not going to go over very well. So I'll put the plug in right here for early communication and to communicate oftentimes with people. We find in our office that oftentimes helps set a tone that will determine, at least will help determine, whether or not these things get resolved outside of court. So, you know, there are certain statutory requirements to communicate, but we encourage people to communicate even earlier and more often if reasonably possible. And along those communication lines, I'll you know, keep going along this thought and say it's important to think about, you know, who is communicating with the property owners as well as, you know, how they are doing it. So, you know, pick someone who's got a good natural way of talking with people. that's not belligerent. You know, it is not surprising. Most people aren't too happy when they find out that their property is going to be involuntarily taken. So just keep these things in mind as you're thinking about how to, you know, keep good PR and avoid some fights and lawsuits. So Utah law also provides a right to property owners that they can accompany the appraiser when the appraiser ends up inspecting the property. Most any time that eminent domain is used, an appraisal will be required. There are a few exceptions to this that, you know, typically if it's going to be estimated to be a value less than $10,000, although there are some lower limits just depending on particular circumstances. But the bottom line is most of the acquisitions will require an appraisal. And it's important to give property owners the chance to accompany the appraiser when they do the inspection, not just because it's statutorily required, but also because, again, this goes to the communication thing I was talking about a little earlier. And that is when people feel like they have the chance to, you know, they're being talked to and understand what's going on, as well as they have the chance to let people know what they think, things just tend to go better. So if a property owner has the chance to tell the appraiser certain things that they feel will affect their property's value, and of course, reasons why it's going to be more valuable, it helps them to be less defensive about the appraisal, and it helps the process move along and them to be more accepting of an offer if they feel like they had a chance to tell the appraiser everything about their property that they thought would increase its value. Once the condemning agency is ready to make an offer, it's got to be a written offer, and there has to be a summary of the basis for the offer. And that's, again, cited there in Utah law. And if it's a single-family residence, then under Utah law, those folks have the right to receive a copy of the appraisal that was done. And if it was not a residence, a single-family residence, then they have the right to know why they are not allowed to see the appraisal if that's the decision of the condemning agency. And, you know, our office feels that in most every case, it's better just to give them the appraisal at that time anyway, even if it's not a legal requirement, just because if it does end up going to court, they're going to have the right to see it at some point eventually anyway, as well as when people are told, no, you can't see this, particularly in this context. You know, they think the worst, and it just tends to lock things up and keep things from being able to move forward as smoothly. There's also a statutory right people have that the condemning agency make at least a reasonable effort to negotiate with them. So it can't be, here's your offer, we're done talking, you know, sign it or we're condemning. There's got to be a real effort here to negotiate with them. And again, that's, you know, hopefully common sense that, you know, the acquisitions will go much more smoothly when people feel like they're being listened to and having a chance to go back and forth with the condemning agency. Now, for political subdivisions of the state, so my understanding is most of the folks listening today, there needs to be a vote taken by the governing body of the subdivision of the government, and prior to being able to file a condemnation action. And so at least 14 days before that vote, before the meeting for that vote, the law requires certain things to be provided. The property owners need to be provided with the Office of the Property Rights Ombudsman's contact information. There is some educational material that our office has prepared. Here's a look at it. This is on our website, and you know, I assume that most of you've seen Your Guide to Just Compensation there that I just held up, but that is on our website. Here's a plug for our website, propertyrights.utah.gov, and that will be on the last slide, so you can take a look at that in case you don't already have it. We have lots of other good information on there, educational information and things that we think you'll find helpful. It's, you know, again, it's not just for property owners, but we're here pursuant to our statutory mandate to provide information to both condemning agencies and property owners. So little plug right there for our website. And then under the current law, there's also a requirement to give a statement telling people that oral promises are not binding. on the acquisition agents or the governments trying to acquire the property, so that people understand that and aren't confused. Another thing required by law in the eminent domain context is participating in our office's process if the property owner requests it. And one thing just to be clear about is, our office doesn't go out soliciting property owners to come to our office. Obviously it's required in the law, as I mentioned, to let people know our contact information, and the information tells them they have the right to come to our office. But we don't, when we find out there's a project along a certain area, we don't go, asking people there to come use our services. But if they do request it, then there are multiple things that our office can do. One is mediation. And again, all of these things are done with the hope and the point being to help resolve disputes and to avoid even future disputes. And so that's really what it's geared towards. And so the mediation there, even though it's a mandatory process for the condemning agency if the property owner requests it, it's mediation. There is no final judgment, and nothing there's no requirement that anyone come to an agreement, either the property owner or the condemning agency. And this is a place where each party retains the right of self-determination, and we're just there as a facilitative process to try and help give people a platform to resolve their disputes. And most often, it's an attorney from our office that will serve as the neutral mediator. And again, just like to stress that we don't represent anyone in these matters. We are a neutral third party tasked with helping both sides try to come to a resolution and resolve any dispute. And just, on a personal note, it's one of the favorite things I do here in my job. I love being able to do that. Arbitration. This is non-binding arbitration under the statute. And so if a property owner tries mediation, or maybe doesn't want to try mediation, just wants to go ahead and have someone issue an award, an arbitration award, we can do that. But as I mentioned, it's non-binding, and so if either party is not satisfied with it, they still have recourse to appeal the award in district court. And so it's sometimes, though, helpful for people to get a reality check when a neutral third party with experience in these areas takes a look and ends up issuing an award that they may not like. It does serve as a reality check. We are also able to order an additional appraisal, and this is at the expense of the condemning agency under state law. And this, again, is used as a dispute resolution tool. And our office's policy is to let the property owner decide who they want to use as the appraiser. And the reason why we do that is so that they will have the greatest chance of seeing the appraisal as legitimate because it wasn't determined for them by a government agency. And people tend to easily dismiss the appraisals that the condemning agency gives them when they're trying to acquire the land because they think, well, this appraisal came from the government. Of course it's going to be biased in their favor. But when they have the chance to pick the appraiser, they know that it wasn't a biased appraiser. And so when the appraisal comes back, again, oftentimes it's helpful to give people a reality check on some of their views of the value of their property. And when they understand through working with our office that it's unlikely that they're going to be able to get more money than an appraiser has indicated, or that's set forth in an appraisal, it really does help the dispute resolution process. And so we try to maximize through our office policies the ability of this appraisal to help resolve disputes. And as I mentioned earlier, if the condemning agency is a political subdivision of the state, it's required to take a final vote authorizing the condemnation or the eminent domain action. And there's a requirement that 10 days advance notice be given to the property owner before the meeting, and then during the meeting, the property owner has the right to speak. And again, even if it's sworn in statute, hopefully that would happen just because people tend to feel a lot better when they feel like their voice has been heard. And so, but in any event, that's a legal requirement for governmental entities. And then the last, another thing here before condemnation can move forward is it must appear that the use of the property will commence within a reasonable period after the condemnation. So under Utah law, you can't condemn a piece of property if it looks like you won't actually use it for the next 10 years. And you know, I've looked for this. I'm not aware of any court case that defines what reasonable period is. So I can't offer a more specific time, but at some point I think most of us will have a good idea of what would be reasonable and what would not in most instances. So there's an overview of the eminent domain process with some of the laws, how it's set up, and the constitutional foundations. And so now we can move on to the property owner rights. And some of these will be redundant with the points that we just talked about here a little bit ago. But as the write-up for this eminent domain presentation here said, sometimes public projects require private property. And so we want to go ahead and highlight again the rights that property owners have when that has to happen, when eminent domain needs to happen, and folks need to involuntarily give up their property for the public good. So there's a constitutional right, as we saw, to just compensation. And I want to dig into this right a little more here. And I'll go ahead and use a simple example to do it. So just compensation has been interpreted by the courts to mean fair market value. And so say, for example, a property owner has a 1,000-foot vacant parcel of land, and that parcel of land is worth $10 a square foot. So if the condemning agency needed to acquire the entire parcel, they would go ahead and pay the $10,000 to acquire that 1,000 square foot parcel of land. And that's, you have to pay the fair market value for the property taken. Sometimes, though, severance damages come into play. And this may come into play when less than the entire property is acquired. So let's go back to that 1,000 square foot parcel. Say, for example, a condemning authority needed to acquire only 100 square feet of that 1,000-foot parcel. They would need to pay the $10 for the 100 per square foot for the 100 square feet, and then say, for example, though, that after that portion of the property was severed from the remaining portion, so they were left with that 900 square feet. Say, for example, instead of the $10 a square foot, the property was now only worth $9 a square foot because of its severance from the remaining portion. For whatever reason, an appraiser says, you know what, in this area, if you're less than an acre, it hurts the property values. That $900 so the $1 reduction to the $9 times the 900 square feet, that $900 is what we would call the severance damages. And that is also a compensable damage that needs to be paid to property owners. And the way that is figured out is based on an appraisal. And there was a recent Utah Supreme Court case called Admiral Beverage that I imagine some or many of you have heard about that helped clarify how we go about valuing severance damages. And this court case made it pretty easy, where there's no longer a determination of what kind of right was it that led to the damages. It's a pretty straight before and after analysis of property value. So it's as it was described in the example I gave you. If the property is worth less afterwards than it was before, it's a compensable damage. It's severance damages. They need to get paid. And then there needs to be a compensation for any other property damages. So say, for example, with this 1,000 square foot parcel, the property or the condemning agency comes in, needs to acquire a 100 square foot strip to put in a road. And so they acquire and fee the 100 square feet, but they also need to get a temporary construction easement over another 200 square feet of the property. And so they pay for the value of that temporary construction easement. But during the construction, say, there was sod and a sprinkling system that was on that property. And with the backhoes going over there, it rips up the sod and takes out the sprinkling system. Well, that is a property damage that needs to be either replaced by the contractor at the end of the project, or the condemning agency needs to pay the property owner the value for that property that was damaged. And so those are the three subparts to just compensation. We have mentioned earlier that property owners have the right to only have their property taken for a public purpose. And so if it's not a public purpose, they have the right not to have their property occupied or taken by a government through eminent domain. Again, we saw that it has to maximize the public benefit and minimize the private harm. There needs to be a written offer and explanation of its basis given to the property owners. And again, I mentioned the appraisal, where it's a single-family home, they need to have a right to a copy of that appraisal. And even if they don't have a right to a copy of the appraisal because it's a commercial property or another property, not a single-family residence, they have the right to know why they can't see the appraisal. And they have the right to the Ombudsman's assistance. This here is a picture of Brent Bateman. He's the lead attorney in the Office of the Property Rights Ombudsman. He's my boss, and I thought, never hurts to throw up a picture of your boss. So there you go. That's him. And there are 3 attorneys in the office: Brent, myself, and then another gentleman, Elliot Lawrence. And all of us are happy to help property owners as well as governmental entities with questions. So what we do is we can provide information about the process of eminent domain and give property owners information on their options. And sometimes just doing that is really helpful for people, and we never hear from them again because they understand what's going on and what they can do about it under the law. We also provide assistance in negotiating with the condemning entity. We don't represent property owners, as I said, but we can be that neutral third party to help convey offers back and forth or to clarify things, and we're happy to do that. I mentioned the additional appraisal that this Utah state law gives us the right to get if we feel it's reasonably necessary to help resolve a dispute, and that is at the condemner's expense, as I mentioned. And again, we found it to be a really powerful tool to help resolve a lot of disputes. There is mandatory mediation or arbitration, and I went over that again, and we also find that we're able to resolve a lot of disputes. Both Brent and I, within the last day, for example, helped settle a dispute in a condemnation matter, and got to the mediation, and the parties were willing to settle. So that was 2 of them here in the last day. As I mentioned, there's also an opportunity, and this is a property right given in statute, that property owners have the right to an opportunity to accompany the appraiser. And that's something that may not always be thought of as a property right, but it is, and it is granted in statute. As I mentioned, folks have the chance to speak in the public meeting if it's a government that is doing the condemnation. They have the chance to speak in that public meeting before the vote is taken. That's a property right they have. And they have the opportunity to negotiate, with the condemning authority. Again, it can't just be a situation where folks come in and say, this is your offer, take it or leave it, we're not talking with you anymore. Again, that's highly unhelpful in helping to avoid PR problems and litigation, but it's also a statutory right to have.
Jim, we have a question.
Oh, yeah.
I have a question about the FAA or another organization condemning municipal property.
Yes. Now, that's an interesting question, and the way that the Utah law is set up, people can condemn government property if it is for a public purpose. For example, there's a situation involving some of UDOT's property that was being condemned by another governmental agency, and it doesn't necessarily have to be governmental. Property can be condemned if it is for a more necessary public purpose.
So
And
utility use.
Yeah, and that it gets a little complicated here. I don't want to flesh this out too much, but the bottom line point I want to leave is that it is possible. And again, there's certain things that have to be complied with, and taking a look at is it already, is the property already fully used for a public purpose, and things of that nature. But the bottom line is, it is possible to for another party to come and condemn governmental land. Again, if it's already being used for a public purpose, it's not going to happen. But if it's planned for some future thing, or they're just holding it for other purposes, then yeah, that land can be condemned. Is the bottom line. And if if the folks out there have a particular question, I'm happy to give me a call, and we'll take a look at it and give you some more specific information and get you the statutes and even some case law that would be helpful for you.
So and I think you explained this, but so in the event, so a city or another organization, government organization, they have a detention basin or a park or something like that, and the point that was given here, the FAA or a airport says we need to expand our runway because it's already a given use.
Yeah, and I got to be careful because if it goes into federal, that's a different ballgame.
Okay.
This is I'm just talking here under state law, and want to be clear about that because the feds have their own rules, and that's totally out of our jurisdiction.
So in that case, it would be best for them to give you a call, and you could look specifically into that.
We could make sure and see what's going on, and make sure it is truly a federal use, for example, and even try to figure out what's going on and offer the assistance that we can on that. Absolutely. So yeah, if there is a specific situation that's coming up, please give us a call.
Okay, great, Jim. Thank you.
We'll help you out with it. So, yeah, thanks for that question. It's there was a recent case that came down where dealing with this particular issue. It was in a state context though, so it was a person who's trying to condemn property under state law from a state agency. It was owned by a state agency. So anyway, it does happen, and there is case law on it. Of course, folks have the right to a jury trial if they end up not resolving the dispute. They can go to trial and have the right to have a jury of their peers decide what the value is. Okay. So the third point that we said we'd be talking about today are some of the hot eminent domain issues that we're seeing right now and what we might be expecting to see and will see here at the legislative session coming up here. As I mentioned, we have been working with a legislative task force comprised of a variety of stakeholders, both from the Private Property Rights Coalition as well as governmental agencies, as well as utilities and others who would on occasion use the power of eminent domain to further their public purposes. And in these discussions, I would say that the hottest issue has been the question of unlawful takings. And this would occur where one of these condemning agencies, instead of going through the condemnation process, they end up simply occupying the property and taking the property, and without, again, properly condemning it, which is an unlawful and unconstitutional taking. In discussions with this group, it doesn't sound like this is happening a whole lot, but it was happening enough that it has come to the attention of the legislature, and they asked our group to take a look at this and come up with some recommendations on how to address it. Again, if you need to take private property for public purpose, it simply can't be done without just compensation, and it can't be done without following the condemnation or the eminent domain requirements under Utah law. So the way that it's being handled right now as a proposal in a bill that should be that is going to be run here this next legislative session, is to give the Ombudsman's office the ability to issue an advisory opinion, which is where our office goes, looks at the facts, and determines whether or not this taking was done unlawfully or not, or whether the condemning agency actually had the legal right to be there in the first place. Because sometimes there are easements, or whether they be prescriptive easements or otherwise, that give folks the right to be there, even if the property owners don't like it. But again, the proposal is that our office would have the ability to issue an advisory opinion on that. And if we find that the condemning agency did not have the authority in our advisory opinion to do this, and the agency does not decide to get off the property and go through the condemnation process, if the property owner then ends up going to court over it, a judge would then have the ability, not the obligation, but the ability to award attorney's fees. If the judge found that there was no colorable claim by the condemning agency to be on that property. So again, that's something that we expect to see here in the bill this coming session of the legislature. So I'd say the other topic, it wasn't quite, certainly as controversial or as hot as that previous topic, but we did spend a fair amount of time talking about the form of written notice that is given to the property owners. As I mentioned earlier here in this presentation, property owners need to be given our office's contact information, the Your Guide to Just Compensation booklet produced by our office, as well as a statement that oral communications are not binding. This group decided they wanted to strengthen these disclosures and actually come up with basically a required letter to give to people along with this information that would give them some further information on the Ombudsman's office and some of their other rights. And so this would be something that would be given along with that prior information. It also increases the waiting period after giving this notice before a condemning agency can actually institute eminent domain proceedings. And the number right now is 30 days. So a condemning agency wouldn't be able to move forward with a condemnation until 30 days, at least 30 days after these disclosures and information were given. So there, as I mentioned, our contact information, our website, email, and hopefully you won't hesitate to use this as a resource, particularly those of you who don't deal with this a whole lot. We found that it has been helpful, and we've actually had quite a few condemning agencies come in who don't do this a lot, and just have a chat with us, and we can go over some things, provide you with some materials, and we're there to bounce things off of and make sure that you're feeling comfortable with how you're proceeding. And I assume there's going to be some questions, and I'm happy to take those.
We have a number of questions here, Jim. One says, your office sees these matters from across the state. What is the most common issue, mistake, oversight, et cetera, that you would advise local entities to be aware of when they engage in a condemnation? I would say on that, it may not even be so much of a legal mistake, but just more of a tactical mistake. And that is that communication thing that I mentioned earlier is big. When folks, because we get calls a lot from people, complaining about how they were treated, and so that goes to, when were they first told about the condemnation? What was the attitude of the acquisition agent or the other representative of the condemning agency that was dealing with the property owner? We get lots of, and we get that it's from people who are not happy about what's happening to them. But some of the stories are really quite compelling, and frankly, we scratch our heads a little bit, given that given what is trying to happen, and just knowing in advance that this is going to be emotional for a lot of people, that more care is not taken all the time in how property owners are approached, how often they are communicated with, and just making every reasonable effort
just to make sure that people feel like they're being kept in the loop and that they're being treated respectfully. Some people you just simply aren't going to be able to satisfy, and you can be the nicest person in the world and they'll think you're a jerk. I mean, that's just the way it is. But we have noticed a recent project actually just completed up in here in northern Utah where there was a major acquisition of residential property mainly, but some commercial property, and the folks that were doing this went out of their way to be helpful, full of information, and for lack of a better term, I guess, kind to the people that were being condemned, and they had very little problem. People will still come to our office and say, I don't agree with this valuation, but we can, when that emotional tension is not present, it's a lot easier to get that additional appraisal, give people their reality check, and help them, feel at least like they were treated fairly and resolve the dispute, as opposed to if they start taking things more personally than they needed to because of how they were treated. So I'd give that as a long answer to communicate often, even if it's not legally required, and try to, to the extent possible, be kind.
Okay, great. Next question that we have was, under what circumstances have you seen courts grant and not grant orders for immediate occupancy? Are there common circumstances?
I would say as a general rule that's gonna happen, and that's what we tell property owners who come to us, because oftentimes instead of getting those orders of immediate occupancy, the condemning agencies just want to get a right of occupancy agreement. And so they'll give that to the property owners, and the property owners will come to us and say, hey, what is this? What's going on? And our typical approach with people is that, more than likely this is going to, they can go to court, sue you, start the condemnation proceeding, and the judge will grant this, more than likely. And so you might as well just sign the right of occupancy agreement and save everyone, including yourself, property owner, the hassle of having to go to court. So I don't necessarily have any kind of specific circumstances, other than to say, as a general matter, we just assume it's going to happen, and it does happen.
Okay, along with that, there was another question right along that. It says, how long can a right of occupancy agreed to by both parties exist before a final settlement has to be reached? In other words, I have an instance where a party agreed to allow us onto his land for public purposes, but because of encumbrances he has with other entities, he's been unable, unwilling, or whatever to clear all that up so that the clean title can be transferred.
Sure. Yeah. And, at some point, I'm going to say that to answer specifically the question, there's not really a set time, but at some point, if you have the right of occupancy, and there's a time period in there, you can move on to condemnation if you've reached the end of that time period. And, you don't have to, that doesn't need to last indefinitely. And so, in terms of, is there a statutory requirement of length or anything like that? No. But, we see the right of occupancy as a tool that lets the project move forward while folks keep negotiating and try to resolve the dispute. But at some point, you can move forward with condemnation if you're not getting the title of the property that you need. And again, there's not a statutory limit on what that time period, what you can put in that agreement. You can put what makes sense for your situation.
Well, good. Well, just for a second, I'm going to open a poll here and just kind of take the temperature of the group here and see if they have a current. What I asked is, your entity have a current eminent domain situation going on? Just to kind of have an idea of what percentage would have that out there. And anyway, as we're doing that, as I let that run, I just want to let people know, if they have a question, please go ahead and type it into the chat box, and we can have Jim answer that. All right. I'm going to close that poll. And it looks like we have about 60% are no. 0% are yes, but they just want to know. so that's really good. I just want to see here. I don't see any other questions coming in. Okay. Any last words?
Well, for me, I'll say thank you. I really appreciate the invitation here and the chance to speak on this. And again, just want to encourage anyone that particularly if you don't do this a lot, feel free to give us a call. We're happy to talk to the attorneys. If if you're a small a small government there, and you just need to ask us something, feel free to give us a call as well. Directly, we do that a lot. People call us, and we're just here to help out. We're here to try to avoid disputes, resolve disputes, and we're happy to chat. So,
okay, great. I just want to wrap up with just a couple of things. We had some issues. We sent out a blurb yesterday reminding people about this. We had quite a few people sign up, and for some reason, those people who signed up yesterday weren't able to get into the webinar. And so I apologize for that, but we have recorded this session, and we will be posting that up on our website. Our IT guy is not in the office today, and so it'll probably be tomorrow when we get that posted up, and then you can go in and watch that at your convenience. We will send out the link to that recording to all the people who've signed up, so you can go back and review this anytime you want. And we really encourage you, if you have a situation like this, pull the council, commission, board, whatever it may be in, and rewatch this, because this has been some great information we've had today, and we really appreciate the Ombudsman's office and Jim in particular for coming in and presenting for us and helping us out. Thanks so much. Everybody go out and have a good day.
Thanks.
All righty, I'm stopping the recording. There we go.